and welcome to our seminar this afternoon by the Clinical Negligence Group at 2 Temple Gardens. My name is Anna Hughes, and along with my two colleagues, Roger Harris and Sam Stevens, over the next hour, we're going to look at 3 hot topics in clinical negligence. I'm going to begin by looking at secondary victim claims. I'll then hand over to Roger, who's going to look at the issue of contributory negligence. And finally, Sam will consider contribution claims. We've got a jam-packed schedule of what we hope will be useful talks for you this afternoon, so we might not have time at the end for questions. But our details are all on the website, so if there is anything you'd like to ask any of us, please don't hesitate, just give us an email afterwards and we'll do our best to help. So secondary victims, we are all very familiar with secondary victim claims and the principles that will apply. However, sometimes when confronted by the factual nuances of the particular case before us, we can come unstuck. In particular, there have been a number of cases in recent years which have led to confusion as to how some of the Alcock criteria are to apply. The aim of my talk this afternoon is twofold. I'll begin by looking at some of the recent cases in this area and explain how the courts have approached the various limbs of Alcock. And secondly, I will provide some practical guidance on how to approach cases that you're faced with in your daily practice. The case of Alcock, which arose from the Hillsborough disaster, set the foundations of the law in this area. Various family members and loved ones of those killed brought claims in their own right for psychiatric injury they suffered, either from being at the grounds or from watching events unfold on TV. None of the claims in that case succeeded, but the House of Lords confirmed the criteria that a claimant needs to establish in order to show that the defendant owed them a duty of care in circumstances where the primary victim of the negligence was another person. Those criteria are, firstly, a close tie of love and affection to the primary victim. Secondly, proximity to the event or its immediate aftermath in time and space. Thirdly, direct perception of the event or its immediate aftermath. Fourthly, that they in fact suffered a recognised psychiatric injury. And fifthly, that that injury was caused or induced by a sudden, shocking event. Finally, it's got to be reasonably foreseeable that a person of normal fortitude may suffer psychiatric injury due to shock in those circumstances. So how are they applied? Well, turning first to the criteria of love and affection. Contrary to what's often thought, the types of relationship that can give rise to ties of love and affection are not closed. The focus in the individual case ought to be on the closeness of the tie. There are some relationships in which such ties will be presumed. So, for example, husband and wife or parent and child. But there are 2 points that are important to emphasise. Firstly, it can be found in other types of relationship. And when it scrutinises the case law, we can see examples where grandparents have been awarded damages. In any case, the burden is always on the claimant to prove the close tie of love and affection. Secondly, and a point for defendants to note, is even in cases where the close tie is assumed, it is not an irrebuttable presumption. In fact, you can adduce evidence to show that on the particular facts of that case, the husband and wife were perhaps estranged, or indeed that the relationship between the parent and child had deteriorated. And if you do that, then it won't be awarded. The second point, and where I really want to focus most of this talk today, is in relation to proximity. The need to establish proximity is a hot topic at the moment due to 2 cases which are to be heard in a conjoined appeal before the Court of Appeal this summer. Both cases began life as strikeout applications brought by NHS trusts that were heard by Master Cook. The first is Paul and Wolverhampton NHS Trust. The claimants in Paul were the young daughters of Mr. Paul, who'd been admitted to the defendant's hospital with cardiac symptoms in November 2012. The claimants alleged that the defendant's staff negligently failed to diagnose his ischemic heart disease and occlusive coronary artery atherosclerosis. On the 26th of January 2014, Mr. Paul was out shopping when all of a sudden he suffered a heart attack and collapsed. By all accounts, the scene was sudden and shocking, and the claimants were understandably distressed. It was said on the claimant's behalf that Mr. Paul's collapse was the first manifestation of the defendant's breach of duty, and that as a result of witnessing this event, they both suffered psychiatric injury. The defendant successfully applied to strike out the claim on the basis that there was no relevant event, as the heart attack was not such that it could be considered to have been an event. Further, the master held that it was, as the negligence in this instance was in 2012, the requisite degree of proximity to establish liability was absent. In reaching his conclusion in Paul, the master felt that he was bound by the decision in Taylor and Somerset Health Authority. Now, in that case, the claimant's husband suffered a heart attack at work caused by the defendant's negligent failure months earlier to diagnose and treat his serious heart disease. He died shortly after being taken to hospital. The claimant went to hospital where she was told of the defendant's death and identified his body. In that case, Mr. Justice Auld found that in order to recover damages, the claimant needed to establish an external traumatic event as a starting point in order to enable the court to look at proximity. The claimant and Taylor had argued that the death constituted that event, but that was dismissed because Mr. Justice Auld found that the law required an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death, and then perception by the claimant of the event as it happens, normally by presence at the scene. There was no such event there because the heart attack was a final consequence of the defendant's negligence in the deceased's deteriorating heart condition. Moreover, the claimant didn't witness it. She was told about it when she arrived at the hospital by the doctors. Master Cook felt that Taylor was on all fours with the decision in Paul and therefore felt bound to strike the claim out. The claimants appealed in Paul and their appeal was heard by Mr. Justice Chamberlain. Now, I would recommend that you read the judgment as he sets out a wonderfully succinct yet comprehensive analysis of the case law in this area. And it's of note that having performed this review of the relevant authorities, the judge prefaced his decision by acknowledging that they seem to demonstrate a degree of frustration about the lack of coherent principle underlying the law governing claims for psychiatric damage suffered by secondary victims. But nonetheless, we'll plough on and try and find our way through it this afternoon. Mr. Justice Chamberlain tried to provide some clarity on the topic. Before we get into it, it's really important to remember that proximity is used to mean two different things when it comes to secondary victim claims. Firstly, as with any claim in tort, in order for a claimant to successfully argue that a duty of care is owed, in line with the neighbour principle established long ago in Hughes and Stevenson, a claimant must show proximity to the defendant. When it comes to secondary victim claims, one determines that broad question of whether there is proximity between the claimant and the defendant by looking at whether the claimant can bring themselves within the control mechanisms in Alcock. The second use of proximity in the secondary victim context is that when you are then looking at those Alcock criteria, the claimant also has to show that they can establish proximity to the event or its immediate aftermath. Mr. Justice Chamberlain therefore made it clear that this narrow issue that he was concerning himself with was that issue of proximity to an event, not any general question of whether there was proximity between the claimant and the defendant. He then outlined what the key issue in Paul was, namely whether the heart attack was capable of constituting an event for Alcock purposes. The first point he noted was that the requirement is for proximity between the claimant and the event, not the negligence which gave rise to the event. Indeed, it's of note that the defendant in Paul was keen to point out that it had never sought to argue that there needed to be proximity between the claimant and the negligence. And that's clearly right, and it's best illustrated by way of an example. Let's say some scaffolding was negligently erected, and 6 months later, a mother and child are walking past, and the mother witnesses the scaffolding collapse and kill the child. If the mother then went on to suffer PTSD as a result of witnessing that, no one would seriously argue that her claim ought to be barred because she wasn't there on the day the builders were erecting the scaffolding. The second point that he decided was to deal with the defendant's argument that to establish proximity to the event, the claimant had to demonstrate proximity to the scene of the tort. Mr. Justice Chamberlain said that that submission was wrong. It wasn't a requirement. He reasoned that once it's accepted that there's no requirement for the negligence and the damage to be synchronous, the scene of the tort can only reasonably mean the scene where the damage first occurred. Now, in Paul, the defendant argued that the tort had become actionable in or around November 2012 on the basis that at that point, a biological process which led to the heart attack had been set in train. The judge said that this argument failed as the question of whether there in fact had been a biological process that had started in November 2012 was a question of fact which would no doubt need input from experts. And he pointed out that because he was dealing with a strikeout application, he was bound to approach the same on the factual basis that was most favourable to the claimant. And the claimant in their pleading had been clever and had asserted that there was no indication that any damage had been caused prior to the heart attack. The judge then went on to consider the defendant's secondary submission based on Taylor and Somerset, namely that a heart attack was not capable of constituting an event that could give rise to liability as a secondary victim because it wasn't an external traumatic event caused by the negligence which caused injury to a person or death. He dismissed that argument by asserting that there had been a misunderstanding as to what external event meant in this context. The judge remarked that if the defendant's reading of it was accepted, namely that the event had to be external to the primary victim, then this would preclude recovery in all cases where the injury to the primary victim was caused by a negligent clinical omission, as those events would never be external to the primary victim. He said, therefore, that the proper reading had to be that the event was something which was external to the secondary victim. Based on this, he said the event in Paul, namely the heart attack, was a proper event because that was something that was external to the claimants that they witnessed. In my view, what commends the judgment of Mr. Justice Chamberlain is that he does set out clearer rules for lawyers to follow in what is undoubtedly a very tricky area. However, I do consider he has applied a heavy degree of artistic license when trying to explain how his decision in Paul squares with the case in Taylor. There was a final issue that was discussed in Paul, albeit that the comments on this are obiter. And that is, what would the position have been if it was found that the defendant's negligence had caused actionable damage prior to the heart attack? The claimant argued that even if there had been some actionable damage caused prior to January 2014, this wouldn't preclude recovery, as the heart attack and the collapse was the first thing that could be properly described as an event, and there was no case law to the effect that an event had to coincide with the first actionable damage to the primary victim. Somewhat surprisingly, the judge accepted this and stated that if it did become necessary to limit what could amount to an event, so as to keep the floodgates shut in these cases, it would be to state that the event was when the primary victim and the damage to them first becomes manifest. Now, it's this last issue that was key in the second case that's going on appeal to the Court of Appeal, and that's the case of Paul Mayer and the Royal Cornwall Hospitals. The Paul Mayers were the parents of Esme, who, when she was 6 years old, was investigated by the Defendant Trust on account of episodes of breathlessness. No cause for the episodes was found, and she was discharged from their care in February 2015. The episodes, which were severe, continued, but before she could be seen again at the hospital, she sadly collapsed at school and died. Both parents were present in the immediate aftermath, and indeed one was even involved in the resuscitation attempts. The cause of death was undiagnosed pulmonary veno-occlusive disease. The defendant argued that the claim should be struck out, as Taylor and de novo meant that the death occurring as it did 5 to 7 months after the negligent failure to diagnose could not satisfy the proximity control mechanism. And in particular, they sought to argue that as a result of the negligence, Esme had suffered further episodes between February 15 and her death, and that these episodes, or the first of those episodes, would have been the first occasion on which the defendant's negligence became manifest, not her death. The claimant argued to the contrary that no, the first time the negligence had become manifest was the death, and that the earlier episodes were, for a plethora of reasons, not relevant. Master Cook, perhaps one might say, burned by what had happened in Paul, conceded that he did not find the issue before him an easy one to decide. He rejected the claimant's submission that the earlier episodes between the negligence and death were not actionable. He said no, if Esme had been alive and had wanted to sue for those, she would have had a completed cause of action. So what he said the question that he needed to answer was whether the fact that there had been non-fatal episodes after the negligence precluded recovery by the parents in relation to the secondary victim claim. In the dying paragraphs of his judgment, he answered that by re-looking at the wording of Mr. Justice Chamberlain and Paul. And he noted that when dealing with the issue of prior actionable damage, all that Mr. Justice Chamberlain had stated was, if it was necessary to identify a stopping point after which the consequences could no longer qualify an event, then that would be when the negligence first became manifest. Master Cook said, well, I don't think it is necessary in the current context to do that, and therefore he refused to strike out the claim. We could spend hours analysing why, but that decision is plainly wrong if the obiter comments in Paul are correct. It will be interesting to see what the Court of Appeal makes of this matter. I remind myself that in Alcock, the House of Lords sought to establish the limits of the law in this area and proclaimed that what they were doing was setting out the rules that would take the law to a place where it could say, thus far and no further. Would they really consider it's right that now claimants can recover damages in cases where the event falls some 14 and a half months after the negligence? We'll have to wait and see. Just briefly before I hand over to Roger, the other criteria I would draw to your attention is that you've got to see or hear the event. And that was said in Alcock, but in Alcock, the Lordships did rely on the fact that these events were watched through TV, and at that time, broadcasters had very strict regulations about what could be shown. It's got to be doubted whether this would survive Twitter and YouTube, where you can see videos that are very graphic shown. If a relative saw that, would we really say that that wasn't enough? You've also got to establish the recognised psychiatric injury and that it was caused by the shocking event. Both of those are questions which you will need to adduce expert evidence upon, and experts should be reminded that they have to be precise in their evidence as to the specific cause. The events must also be sudden and shocking, and we all know that shock in the context of this cause of action involves the sudden appreciation by sight or sound of a horrifying event which violently agitates the mind. That's an objective test and context is relevant. It will be more difficult to show in a hospital setting. A common mistake that's often made by both sides is to ask the experts to comment on whether they think the events were shocking. Simply put, it's none of their business. It's a matter for the court, and so they shouldn't be opining on it. Finally, I want to leave you with 3 practical tips. First of all, for claimants, what we've demonstrated over the last 15 or so minutes is that the law on secondary victims is all in a muddle. So the first analysis that you should perform in your case is, can I argue that my client is in fact a primary victim rather than a secondary victim? This will be advantageous, as in line with Page and Smith, in claims by primary victims, the only question is whether the defendant was under a duty of care to avoid causing personal injury to the claimant. If so, it's irrelevant that the type of injury suffered was psychiatric, and you do not need to bring yourself within the Alcock criteria if you can show you're a primary victim. Secondly, as noted at the outset, the Court of Appeal is to hear the cases of Paul and Palmer together this summer. As for defendants, the position can only really get better as far as you're concerned, so it's clearly better that if you do have a claim that involves one of those issues, it's best to try and stay that. And indeed, claimants, it's not the case that you should be pushing for it to go ahead, because actually, given the importance of the decisions, judges are likely to be pretty unimpressed if they're pushed to decide these cases without this guidance. Moreover, you want to avoid pleadings having to be re-amended if, in fact, the law changes by the Court of Appeal's decision. And thirdly, it's the point on strikeout. Strikeouts became very popular in secondary victim claims, and it's no coincidence that their popularity increased with the advent of quacks. However, what you've got to remember in any strikeout application is just what was said by Mr. Justice Chamberlain, namely that the assumption has to be that the case is decided on the facts most favourable to the claimant. And so for defendants, that may not always be the best way to get rid of your claim. Well, that's enough from me. I am now going to hand over to Roger, who will deal with cases on contributory negligence.
Well, thank you, Anna, for a characteristically trenchant talk. As Anna says, we turn to the issue of contributory negligence. And as someone who practices in the fields of both personal injury and clinical negligence, I've always been struck by the contrast between the ubiquity of the defence in the personal injury cases and its rarity in clinical negligence cases. And what I intend to do today is to look at the concept first in general terms and see whether there is any reason why it shouldn't apply in clinical negligence cases, and then to look more specifically at three specific areas: the failure to follow medical advice, smoking cases, and suicide cases. Now, the starting point is obviously the 1945 Act. That provides, as you will no doubt all recall, that where any person suffers damage as the result, partly of his own fault, the damages recoverable shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. And responsibility, as we are repeatedly told, has two elements: culpability and causative potency. In terms of culpability, Lord Denning perhaps put the matter most succinctly in Froome and Butcher, which you'll all recall as the seatbelt case. Claimant is guilty of contributory negligence if he ought reasonably to have foreseen that if he didn't act as a reasonable, prudent man, he might be hurt himself. It's worth remembering the fact that someone is free to do something. The fact that someone is free to do something doesn't mean they can't be guilty of contributory negligence. As Denning put it rather pithily in relation to seatbelts, which of course were not mandatory at the time, Parliament didn't make it compulsory for anyone to wear a seatbelt. Anyone is free to wear one or not as he pleases. Free in this sense, that if he doesn't wear it, he's free from any penalty by the magistrates. Free in the sense that everyone is free to run his head against a brick wall if he pleases. He can do it if he likes without being punished by the law, but it's not a sensible thing to do. If he does do it, it's his own fault, and he has only himself to thank for the consequences. Fault, therefore, is not a particularly high hurdle for defendants to establish. One suspects that acts of or omissions of a great many clinical negligence claimants would indeed satisfy that hurdle, whether it's smoking or missing appointments or causing injury in the first place. So we turn to causative potency. And the first point to remember is that we're looking at causation of the damage and not the immediate cause of any incident that gave rise to it. And the second point is that the concept that is frequently invoked as the touchstone for causative potency is common sense. As Lord Reid put it in Stately, the question must be determined by applying common sense to the facts of each particular case. One must discriminate between those facts which must be discarded as being too remote and those which must not. Lord Reid also referred to the previous decision of Viscount Birkenhead, in the case of Admiralty Commissioners, in which the matter was put like this: the question of contributory negligence must be dealt with somewhat broadly and upon common sense principles as a jury would probably deal with it. And while no doubt where a clear line can be drawn, the subsequent negligence is the only one to look at, there are cases in which the two acts come so closely together and the second act of negligence is so much mixed up with the state of things brought about by the first act that the party secondly negligent might invoke the prior negligence as being part of the cause so as to make it a case of contribution. Now, one can see that claimants and defendants might take rather different elements from these passages. For the claimant, this idea of a clear line is one that they will want to suggest is drawn at the door of a hospital. Equally for a defendant, the concept of common sense and the idea that it's a jury question is one that is far more open to creative interpretation. Indeed, as anyone who's ever listened to a Radio 2 phone-in will know, one person's view of ordinary plain common sense can differ rather markedly from another. The woke warriors of Twitter very seldom agree with the disgusteds of Tunbridge Wells. So the fact that the fault line is a pretty low hurdle and causative potency is a matter of common sense about which different judges may have different views might suggest that this is an area that should be full of tricky borderline decisions. But turning to the cases themselves, we see that they are in fact comparatively few and far between. So looking at the first area, failing to follow up medical advice or to report symptoms. This can take many forms: not attending for tests, not reporting symptoms, not rearranging missed appointments. These are all perhaps some of the more common areas. In 2015, I was instructed in a case called Spencer, and in what turned out to be rather bad timing for the defendants. It came before the court about 2 days after judgment had been handed down in Montgomery. It involved the principal allegation of a failure to warn about risk. It was suggested that the defendant ought to have warned a patient who'd undergone a hernia operation that there was a small risk that he might develop DVT after he'd been discharged. Now, the NICE guidelines were pretty vague as to the warnings required, and consequently the warnings that were given were set out in pretty general terms. So on discharge from hospital, he was informed that if he experienced any problems in the next few days, he should contact either his GP or the hospital. A few days after the operation, the claimant did indeed develop pain in both his calf muscles. He didn't report this, as he attributed the pain to a lack of exercise. In fact, the cause of the pain was bilateral pulmonary emboli. It was argued on the defendant's behalf by me that there was contributory negligence because he'd been told to report any problems. This clearly was a problem, and he clearly failed to report it. But the judge held that there was no contributory negligence. The reason the claimant believed the problem was related to exercise was because he didn't know about the risk of pulmonary embolism. And this was precisely what the defendant should have warned him about in the first instance. Consequently, there was no fault on the part of the patient. And I must say, despite being on the losing side of that argument, I don't think one would be critical of the reasoning in that case. In contrast, a case in which the claimant was found to be contributory negligent for not following medical advice was the case of Pigeon, a decision that's now almost 20 years old. It was a case where a claimant developed cervical cancer. She'd previously undergone a smear test, the results were negative, but she failed to attend for further tests despite frequent reminders. She was found to be 2/3 contributory negligent in failing to have further smear tests. There's also a number of Commonwealth cases on the point, which perhaps take a tougher line on claimants that might be expected in English cases. So, for example, there's a case of Locker, which is a Canadian case, in which a patient reported rectal bleeding to a doctor who concluded that it was a result of piles. She failed to report subsequent episodes of bleeding because she thought these would also be attributable to piles. In fact, they were due to colon cancer. And that failure to report the symptoms resulted in a 20% reduction for contributory negligence. In Young, which was an Australian case, a 26-year-old died as a result of coronary thrombosis, attributable to a long-standing coronary artery disease. His negligence involved failing to turn up for tests or to attend appointments or to seek alternative appointments, failure to raise matters with his doctor, failure to tell one doctor about what he'd been told by another, and his contributory negligence was assessed at 50%. Now, I have my doubts as to whether an English judge would have reached the same conclusions in Locker and Young, particularly perhaps in relation to failing to tell the doctor about what he'd been previously told. An English court might regard it as the doctor's duty to extract that information. But these cases do give examples of the sorts of points that are certainly arguable. In smoking-related cases, there are really two different types of scenarios, and there's some indication the courts will approach these matters in different ways. So the first is where the addiction, say smoking or whatever, has resulted in the claimant being in hospital in the first place. Classic example being a patient who develops lung cancer as a result of smoking. But the other scenario is where a patient is given specific advice, for example, in relation to smoking after an operation, which he chooses to ignore. And the analysis is probably rather different in these two different situations. The first type of scenario was considered by Lord Justice Dyson in the case of St George and the Home Office. The first point to note about this is it wasn't actually a clinical negligence case, and that's important to remember given the weight that is often attached to this judgment on this point. The case involved a 29-year-old man who'd become addicted to alcohol and drugs and had been sentenced to 4 months in prison. He was allocated a top bunk. He had an epileptic seizure as a result of alcohol withdrawal, fell from the bunk and suffered serious brain injury. At first instance, there was a reduction of 15% to reflect his contributory negligence. That was overturned in the Court of Appeal. In the course of his judgment, Lord Justice Dyson accepted the claimant was at fault. He accepted that but-for causation was established, but nonetheless overturned the decision. I think it was clearly the right decision. But what he did do, particularly important in clinical negligence context, is he went on to comment on the analogy of that case to a smoker who developed lung cancer and then suffered negligent treatment. And he said in those circumstances, there would not be a finding of contributory negligence because the claimant's fault in smoking or consuming excessive alcohol over a period of time is not, as he put it, a potent cause of the injury suffered as a result of the negligent medical treatment. The fault is not sufficiently closely connected with the defendant's negligence. Rather, the fault is part of the claimant's history, which has led to his being a man who's suffering from a particular medical condition. There's a few points to note or to say about the St George case. The first is that these comments were not part of the ratio of the case. It wasn't actually a clinical negligence case, as I've said. Further, this point had been conceded by defendant's counsel. So it's not actually binding, although it may well be considered persuasive. The second point is that it was a 2008 case. So it was before the Supreme Court's decision in Montgomery, in which there had been this emphasis on the importance of the right of patients to make their own decisions. And it might reasonably be said that the corollary of greater rights for patients is that there should also be greater responsibility for their harmful decisions. And thirdly, and perhaps most interestingly, it appears to contemplate that courts should take a completely different approach to causation when the original cancer is caused not by the fault of the claimant, but by the fault of a third party. Because we're all familiar with the decision in Webb and Barclays of 2001, where the Court of Appeal held that the liability of a tortfeasor for personal injury wasn't terminated by the intervening negligence of the doctor treating that injury, unless the doctor's negligence was so gross as to break the chain of causation. Well, if that's right, then marrying that decision with Lord Justice Dyson's reasoning, then the law would appear to be that if a tortfeasor causes a claimant to develop cancer, which should subsequently have been identified and treated by a GP, the tortfeasor will be responsible for all the consequences, including those the doctor should have prevented, unless the doctor is guilty of gross negligence. But if a claimant develops cancer as a result of her own fault, and there's a failure to identify and treat the same by the GP, then the claimant will not be responsible for any of the consequences that the doctor should have presented. And that, it might be argued, is a surprising position for the law to have reached. And the second type of smoking case involves those cases, say, where there's a failure to follow advice linked to specific treatment. Again, one can look to the Commonwealth for some decisions on this point, and there's a case called Dumas in Hamilton, in which someone was warned not to smoke after surgery. She did, and she developed necrotic tissue. This required revision surgery and led to permanent disfigurement. And although she'd not been told precisely why she had to stop smoking, the court still found her 50% responsible for the damage. And that, I think, is probably a less controversial area and one that the courts in England might more readily follow. And the final area I want to look at briefly is suicides. I think before one gets to the law in relation to suicides, it is important to acknowledge the human dimension in these cases. I mean, fatal accidents can be highly emotive in any event. They can be extremely distressing for claimants. And consequently, there is an understandable reluctance on the part of healthcare providers, whether it be the NHS or private providers, to allege negligence. I mean, do they want to be seen to be blaming patients in circumstances where, but for the breach of their clinicians, the patient would have survived? And I think that's an important point that one mustn't forget. But be that as it may, the courts have been willing to make findings of contributory negligence in suicide cases. So in Reeves, the claimant committed suicide in a police cell after the police had been warned that he was a suicide risk. And the House of Lords held that the fault within the 1945 Act could include intentional acts as well as negligence. Held that the deceased had responsibility for his own life, and they were happy to make a finding of a reduction of 50%. In Reeves, though, the interesting point was that the claimant was found to have been of sound mind. And in clinical negligence cases, that won't normally be the case. There would normally have been a history of mental illness. And so the issue of how to deal with claimants who committed suicide who were not of sound mind came before the House of Lords in Core. It was a very sad case, Core. It involved a claimant jumping, or not the claimant, the defendant, the deceased, jumping from the top of a multi-story car park. He was severely depressed. He'd been found to be suffering from a disabling mental condition which impaired his capacity to make reasoned and informed judgments. And at first instance, the judge had dismissed the claim and had made no finding of contributory negligence. It was largely ignored by the Court of Appeal, but the House of Lords did deal with the issue. Two of their lordships, Lord Bingham and Walker, concluded that impairment meant there could be no reduction for contributory negligence. Two, Lord Scott and Lord Mant, suggested that it may be necessary to attribute an element of responsibility to someone who commits suicide. And in the middle, perhaps, sat Lord Neuberger, who suggested that there was a nuanced approach that was appropriate, and that at one end of the spectrum are cases where the deceased is of sound mind, so there should be a finding of contributory negligence. And at the other end will be cases where the deceased's will and understanding are so overborne by his mental state that there could be no real choice on his part at all because he'd lost his personal autonomy. And it was this nuanced Neuberger approach that was adopted by Mrs. Justice Whipple in the case of PPX in 2019. It was a suicide case where she decided that the extent to which the deceased's personal autonomy was so overborne by his impairment of mind lay somewhere between the two extremes that Lord Neuberger had identified, and so found the deceased guilty of contributory negligence and reduced damages by 25%, or at least she would have done if she hadn't found that there was no breach of duty. So that is something of a brisk canter through this area. In summary, if you're acting for a claimant here, what you want to be doing is emphasising that a clear line should be drawn at the hospital door. You want to be adopting the Lord Justice Dyson reasoning, the argument that the previous fault is simply part of the claimant's history. In addition, it's important to consider, as a claimant, whether actually there was fault on the part of the claimant. Was the advice given by the doctor sufficiently clear that it could be followed? A Spencer type case. Were the consequences of not following the advice sufficiently clearly explained? How did the claimant, for example, know it was his or her responsibility to book a follow-up appointment or to carry out a test? So very close analysis of actually whether there was fault. And equally, one needs to look at whether it would have made a difference. What was the causative potency? Would cancer have been apparent if there had been tests as early as is being suggested there should have been? And on the defendant side of things, the first point I'd make is consider it. Far too often, it's a point that just, as far as I can see, is not considered and not taken when it might be. The fault hurdle, as we've discussed, is actually quite a low one. And the causative potency one is an area where barriers can quite properly be tested. So the first issue is always think about it. Secondly, I think there are grounds for arguing that the Dyson approach is now outdated. Does it really sit happily with the approach in Montgomery? Why is it? Why shouldn't greater rights bring with them greater responsibilities? Why should the test for causation differ depending on whether the person who caused the claimant to be in hospital was a negligent employer or the claimant himself? And if you're looking for inspiration, have a look at some of the Commonwealth decisions. There are far more decisions in Canada and Australia on this sort of issue than there are in England. And they do show that the arguments in this area are perhaps rather more nuanced than English lawyers might believe. Well, I could go on for many hours, but you're relieved to hear my 20 minutes are up. And so I will now hand over to Sam Stevens. Sam.
Yes, thank you, Roger, for that. And good afternoon, everyone. I will be running over some of the key points to consider in a claim for contribution. And unfortunately, I have to start with some points on terminology, so this doesn't become too confusing. And I'll refer to the person who is bringing the claim for personal injuries, so the patient, always as the claimant. I'll refer to the person initially being sued by the claimant as the defendant and continue to refer to them as the defendant, even when considering the defendant's separate claim for contribution themselves, and then refer to the person subsequently sued by the defendant for contribution as the third party. Now, this talk is going to focus on an action for contribution brought under Section 1 of the Civil Liability Contribution Act 1978. And that is a statutory action in its own right, which will usually be the gateway to share the costs of a patient's claim. And the gist of the action is proving that the third party is liable to the claimant for the same damage as the defendant. And so it's different from other causes of action because there's no need to prove some sort of pre-existing duty between the third party and the defendant themselves. But defendants shouldn't lose sight of other potential direct causes of action that they could have against those third parties. Now, in a clinical negligence context, those will usually arise from contracts in one of two forms. The first is potentially a contractual indemnity. Those are often seen between private healthcare providers, hospitals, and independent clinicians working with practicing privileges there. And the second is a breach of a standard contractual term, such as a clinician agreeing with the hospital to exercise reasonable care and skill when treating a patient, or the seller of a medical device warranting that it is of satisfactory quality. So never lose sight of those claims as well. But let's turn then to contribution itself. And it is a large topic, and I will only really be able to cover 4 of the headlines, as it were, of contribution, each of which could be a talk in itself. The first is the liability of the defendant to the claimant. The second will be the liability of the third party to the claimant. The third would be apportionment, apportioning the blame between the defendant and the third party. and I'll briefly touch on limitation as well at the end. Well, let's start with the liability of the defendant. And the simplest but probably rarest way to establish the liability of the defendant to the claimant would be by a judgment of a court in the UK, which is conclusive. But in reality, in most cases, where a defendant seeks a contribution, it will have already settled the claimant's claim. Now, a defendant is allowed to bring a claim for contribution to a settlement pursuant to Section 1(4) of the 1978 Act. Now, the types of settlement, there are some conditions to what types of settlement can be contributed to, but the policy of the Act is to encourage settlement. So in reality, proving that there is an appropriate settlement to found an action should not be difficult in any real case in clinical negligence. Section 1(4) of the 1978 Act provides that a defendant can only seek contribution towards a bona fide settlement or compromise. So it has to be in good faith, the settlement. And what this section does is seek to exclude collusive, corrupt, or dishonest compromises, which in reality, in clinical negligence actions, which are defended by an HSR or another indemnifier, and are being brought by claimants with real injuries, it's unlikely to think of there being a bad faith settlement or a collusive settlement in that regard. But what does the defendant have to do in respect of proving whether they were liable to the claimant in a contribution action? Well, importantly and clearly, the defendant does not have to prove that it would have been liable to the claimant after trial if it hadn't settled the action. And there would be a huge policy issue otherwise, as defendants would be reluctant to settle if they knew they would have to go on and prove their own negligence in contribution proceedings in the future. Now, the relevant wording which gives rise to this policy in the Act is that the defendant must show that it would have been liable, but assuming that the factual basis of the claim against him could be established. Now, this was considered relatively recently by the Court of Appeal in the case called W.H. Newson Holding Limited and IMI PLC. And in my mind, it drives home a pretty clear message on what the courts expect on this. One simply needs to look at the factual basis of the claimant's claim, assume that is all true, and then ask if that discloses a reasonable cause of action against the defendant, such as to make it liable in law to the claimant in respect of that damage. Now, in a way, I think it's a similar process, or it's akin to almost a strikeout test when looking at the pleadings, assuming the facts there are true, and asking, is there a cause of action here that would establish liability? One of the issues that the Court of Appeal had to determine, though, in W.H. Newson was an issue of collateral defences. Now, a collateral defence is where the defendant puts a positive case that could provide a full defence to a claim while still accepting the claimant's pleaded factual basis as being true. Limitation is a perfect example of this. I was trying to think of some more for clinical negligence, and I think one would be perhaps where a defendant pleads a positive factual defence not anticipated in the particulars of claim. For example, if the claimant brings a consent claim and states that she would not have consented to treatment A if she had been warned of the risks. Now, the defendant may admit breach of duty, but say, well, actually, you were also offered treatment B, which you would have had, and that would have resulted in the same outcome in any event. Now, in W.H. Newson, the Court of Appeal held that collateral defences such as that and limitation could not be considered. The third party, in reality, isn't entitled to challenge the factual basis put forward by the claimant with collateral defences. One simply focuses on this strikeout style application, which we discussed earlier. But that in part begs the question as to, we say assume the factual basis of the claimant's case is true. Well, how do you determine what the factual basis is? And it's relatively straightforward in litigated claims. one simply looks at the particulars of claim, possibly the reply, and assume that the facts therein are true. And I think you would take a similar approach in relation to pre-action cases, but look to the formal pre-action correspondence, the letter of claim, and potentially follow-up correspondence as well. But we all know and have had cases where unpleaded risks will emerge during litigation. And how does the court deal with that? Well, in Dubai Aluminium Co. and Stilarm, Lord Hobhouse sort of raised this issue and said it would be really unsatisfactory if a defendant had to sort of corral the claimant into amending their pleadings to put in an unpleaded risk in order to protect its position in a future contribution claim. And so it seems that in the appropriate case, the focus of the inquiry as to what the factual basis of the claim is can go beyond the pleadings. I think an example of this could be in a clinical negligence case, the agenda or the joint statement, where very often these unpleaded risks can rise. But if a settlement is going to make provision for a significant unpleaded risk, particularly if it involves more extensive damage than is evident on the pleadings, it certainly would be prudent to have that factual basis set out in writing, possibly in recitals on the settlement itself. One point to say on this is, in most clinical negligence cases, the cause of action will usually be readily apparent even on bad pleadings: duty, breach, causation. But listening to what Anna said earlier in relation to secondary victims claims, that is certainly an area where the pleadings may not disclose a cause of action. So I'd be, if ever appropriate to seek a contribution claim in that in a secondary victims claim, make sure the actual written claim is fully and properly particularised before settling. Turning then to the liability of the third party to the claimant, it's essential that the defendant proves that the third party was liable to the claimant to get the contribution action off the ground. And Section 6.1 of the Act provides that the third party's liability can come from any legal basis. Now, in clinical negligence, it will mainly be in tort or contract, but one can see how, say in a medical device case, that the producer or importer of the good could be liable under the Consumer Protection Act 1987 as well. Just be careful to focus on the fact that there must be a liability between the the third party and the claimant. I've seen a few cases where the defendant has gone after a pure distributor of a product, and the defendant may have a contractual relationship with the third party, but there's no duty of care between the third party and the claimant or action under the Consumer Protection Act. So just be careful to focus on the duty that's owed between the third party and the claimant. Equally, the liability must be limited to the same damage. So it must be shown that the third party is liable for the same damage as the defendant. Now, in clinical negligence claims, this often will not be a problem because it's usually personal injury to the claimant and the consequent damage caused. Once that route to liability is established, obviously the defendant must then prove the claim. Now, the work for this will be done by the claimant, where a matter is co-defended and contribution will simply be dealt with at trial. But it will, of course, be more difficult where the defendant pursues the third party in separate proceedings. And as such, in those cases, you want to think before settling, do you have everything you need in order to pursue that claim? And it's better to try to get that from the claimant while the claimant still has skin in the game prior to settlement. So think, do you have all the medical records you need to pursue the contribution claim? Will you need a witness statement? For example, in a case where it's a consent allegation involving a sort of finely balanced risk-benefit analysis of whether the claimant would have had different treatment. So those are the issues of liability for the defendant and the third party. What about apportionment? Well, this is governed by Section 2.1 of the Act, and the focus is to basically find what is a just and equitable apportionment between the parties. But it's been narrowed down somewhat in the case of Downs and Chapel, and it is pretty settled law that the court will look at two main focuses. The first is the seriousness of the blame of each party, and also the causative potency of their respective breaches. Now, these will be balanced together, and Lord Justice Hobhouse said in Downs that a more serious fault, which has less causative impact on the claimant's damage, may represent an equal responsibility to a less serious fault that has a greater causative impact. Now, I think in the vast majority of clinical negligence claims where several clinicians are involved, causation will be the key fact, because usually we're talking about simple negligent errors without intent or any gross negligence. And it's hard to give any real guidance on causation itself and the causative potency because it's so fact specific. But one could think of other factors that could be taken into account. One in particular would be the expertise of the relevant clinicians. So if a GP, on the one hand, is liable for repeated failures, early failures, to refer to a specialist, but then when eventually referred, that specialist misses the diagnosis, the respective expertise of the specialist and the GP, in my view, would be relevant to considering who is more to blame or who's more responsible for the damages in the end. It's also important to note the range on apportionment. This can range from a full indemnity of one party through to full exclusion of liability. And I think full indemnity will probably most likely be warranted, where you have, for example, a defendant hospital that is vicariously liable or contractually liable for the actions of a truly independent clinician, and they've had no real impact or had no real contribution to the negligence itself. There's certainly authority on that which supports a full indemnity. Equally, it's important to bear in mind that the third party's liability in contribution will not exceed what it would have had to pay to the claimant, taking into account any legal or contractual limits on liability or contributory negligence itself. We'll then turn finally to limitation, because it's an unusual one in contribution and one has to be careful. A contribution claim must be brought within 2 years. Now, if there's a judgment, it's within 2 years of the judgment. If it's a settlement, it's the earliest date on which the amount to be paid is agreed. And so that's really when the quantum is agreed for the settlement purposes. And note that the agreement is the key point. So if a Tomlin order is agreed and then filed at court, the relevant date is when the Tomlin order is finally agreed, not when the Tomlin order is sealed by the court. A third party is not allowed to rely on an ordinary limitation period in relation to the claimant's claim to defend contribution proceedings. So, for example, if an accident occurred on the 1st of January 2016, the defendant settles proceedings 4 years afterwards, and that defendant can then immediately pursue the third party, and it doesn't matter that the claimant's claim against the third party would be time barred. Now, there is an exception to this, and that's where the limitation period would not just procedurally bar the claim, but actually extinguish the cause of action. And whilst there is some arguments on this, the most likely example in a medical context would be the 10-year long stop under the Consumer Protection Act 1987. There is argument that that is an extinguishing limitation period, not a procedural bar. So do bear that in mind when considering contribution claims based on the Consumer Protection Act. And also do bear in mind that what I've just said is about contribution claims under the 1978 Act. A different period will apply for direct causes of action, say for breach of contract. That will be 6 years from the date of the breach itself. And it's from the date of the breach, not the date on which damage was caused. So that really was a whistle-stop tour of contribution. And really cutting briefly down the key points, but just to take away from this, what I would really advise when considering contribution claims is to really take stock of future contribution claims prior to any settlement with a claimant. Firstly, is the factual basis of the claimant's claim sufficiently clear on the written documents to pursue contribution proceedings against a particular defendant? Sometimes it can only come to light at RTM, but it would help to have that written down. And equally, do you have all the evidence you need from that claimant to pursue the other defendant? The clinical notes, potentially even a witness statement. Could consider asking them for assistance going forward. Well, it does look like we've run out of time, and I apologise for detaining you longer on a Friday than we said we would. We won't have time for questions on that basis, but if you, as Anna said at the start, if anyone has questions, please do get in contact with the clerks, or our email addresses were up earlier, and we will try to get back to you, with a helpful response when we can. But aside from that, on behalf of myself, Roger and Anna, we thank you for joining with us. Hope this has been useful, and wish you all a good weekend. Thank you.